Core, are you able to give us any indication of how you propose to develop your submissions in terms of time at this stage?
Yes. My Lord, I've agreed with Mr. Elvin that subject to your Lordship's fiat, I will just spend up to 10 to 15 minutes on my last topic and hope that I take less than that. And he's content with that.
Thank you very much.
Thank you very much. Thank you for the opportunity. My Lord, therefore, I turn to the last heading, which I've called equivalence, the reality principle, and overcompensation. My Lord, and I say simply this: the case we put forward is based on the proper interpretation of the relevant statutes. Both sides have referred to the principle of equivalence and the reality principle. They were both considered by Lord Justice Lewison in his judgment, as you know. And, my Lord, a convenient place to look at those principles is perhaps our case at AC. At our case at paragraphs 156 and 157, which are at page 265 of the bundle. Paragraph 156, in fact, starts on page 264.
Yes, thank you.
We say that at 27 to 43, Lord Justice Lewison dealt with general principles, began by referring to the principle of equivalence, which I say can be summarised in the words of Lord Justice Scott in the Horn case. Lord, unless you wish me to, I won't read it out, but it's there, and we agree with it. I think it's a proper summary. And similarly, the reality principle, as summarised by Lord Justice Lewison at paragraph 40, is at paragraph 157 of our case. Again, we agree. He then went on, Lord Justice Lewison then went on to say what he said at 43, which we set out at 158 of our case, which again we've said we accept is correct. The courts will resolve statutory ambiguities by applying the principle of equivalence and the reality principle, but they're broad concepts, and where a statute is clear, the court will apply the statutory language. Indeed, however fair or otherwise that might seem. And after all, people can disagree about what's fair. But we say our case is entirely consistent with both the principle of equivalence and the reality principle. The second and third respondents say at 61 of their case, which is at page 292, that our interpretation of the case gives rise to unpredictable, arbitrary and capricious outcomes, which might lead to some of the respondents not obtaining fair compensation. We don't accept that at all. We've shown, and this was the point I was on just before lunch, each CAD application is determined on the evidence that's before the decision maker in relation to that CAD application. And the grant of a CAD on one site does not use up capacity in the way feared by certainly Lord Justice Lewison. And just incidentally, I didn't intend to suggest otherwise when answering questions from Lady Rose just before lunch. All I meant in relation to the example of a CAD application determined 1 week before another is that the evidence, one could expect that the evidence might not be very different just because they were determined so close together. Both the second and third respondent and the fourth respondent, the references are these: 67 for the second and third respondent, page 293, and 54 to 56 for the fourth respondent, 314. Both of them draw attention to the fact that between the launch date, in essence the first publicity for the scheme, and the valuation date, when the interests were finally acquired, their freedom to exploit their land is reduced, as any planning application they might have made would have been determined in the shadow of the scheme. And the fourth respondent says, during the period between the launch date and the valuation date, markets may fall and rise. Well, of course, markets go up and down, and they might go up and down between the launch date and the valuation date. But statute has chosen a valuation date, the time of vesting, and not for the assessment of compensation. That's a choice that the statute made, that the legislature made. And Section 14, which is about planning assumptions, let's remember, protects the landowner from the effects of the scheme on his ability to get planning permission for his land. Because between the launch date and the valuation date, any effects of the scheme in planning terms are stripped out. So the point of the cancellation assumption is that the decision maker is to ask what planning permission would have been granted in the absence of the scheme, and we say CAD applications and decisions on other land may help with that decision. Matter for the decision maker. That's all I have to say. Thank you very much.
Could you assist me, please, on one point?
I'll certainly try.
The issue is identified, the specific issue is identified in paragraph 28 of the Statement of Relevant Facts and Issues.
Yes. 28.
Paragraph 28 of the Statement of Facts and Issues.
Yes.
And could you point me, please, to the specific way in which you would answer that issue? How would you deal with that issue
Yes.
in a paragraph, or where we find that in your case?
Yes, my lord. We've set that out in our case at two places. Paragraph 2 on page 225, and also in the conclusion at paragraphs 162 onwards. That's your bundle, page 266 to 267. I hope that answers your question.
Can you also help with whether there's anything in the upper tribunal's answer to the preliminary issue that you take issue with?
That is, of course,
remind myself of it, if I may.
paragraph 66.
Yeah.
Yes, I've got it. It's page 364. I don't think so in principle, my lord.
In that term, they are not material planning considerations. That's a term of art, I gather. Or
Yes, in
so
essence.
that's not disagreeing with your propositions that they are evidence.
Yes, exactly.
Right.
I've said, and I said, I made a point of saying so this morning, albeit perhaps fairly briefly. I don't say that CAD applications are necessarily of themselves material planning considerations in that sense in relation to a CAD. What I do say is that they may, depending on the circumstances, be evidence of the matters that we set out at paragraphs 2 and in the paragraph 2 of our case and in the conclusions. So I don't want there to be any. I'm grateful to you for asking that, because I don't want there to be any misunderstanding. I think one has to be. I have to be a bit careful with how I use the expression material planning consideration, because it does end up being a term of art. And so that's my case. I say that they can be evidence. I hope that's helpful. I hope that answer assists, my lord.
Thank you very much.
Thank you very much.
Sorry, David.
Yes, if you don't mind, we're just going to do a bit of house moving. Yes, a bit of choreography.
Quite understood. Take whatever time you need to sort out your...
We'll just going to come and sit next to me in case I forget it.
Shan't be a minute.
Space.
They're all saying roll over and the little one's going to fall out.
Let me take all this out of your way. She's not the lector. Just move it.
It means stereo.
Mr. Owen.
May it please the court. Can I just begin with a couple of preliminary observations, particularly the observation that submission Mr. Corner made right at the end, that they're not material considerations, but you can take them into account as evidence. That is mutually self-contradictory. Under Section 70 of the Town and Country Planning Act, the local authority will determine an application having regard to the development plan and other material considerations. Evidence, if it's relevant, is a planning material consideration. If it isn't a planning material consideration, it is by definition legally irrelevant. So I do not understand the Secretary of State's submissions on that point. The second point I would make is that it is a distinction without a difference. The edifice upon which the Secretary of State now builds its case, which is not the same as in the Court of Appeal, but let that be. I will deal with the matters as they stand before you. The edifice upon which this is constructed is to draw a distinction between the CADs and evidence. Now, I don't, with respect, understand what the Secretary of State's saying, because the evidence as to what may be in CADs is actually the CAD itself. Can I ask you just to turn up one of the CADs by way of example? And it's the second respondent's Quintain's CAD. It's at page, if I can read, 366. The CADs are in order in that, beginning with that one in the bundle. And you'll see what the CAD sets out is what the local authority, subject to appeal, considered to be appropriate alternative development. It is the content of the CAD that the Secretary of State wants there to be the ability to take into account on other CAD applications. So it is a distinction without a difference to say we don't want to take account of the CAD because they're one and the same. So far as evidence of planning considerations...
Sorry, just on that, I thought the Secretary of State wanted the application for the CAD to be taken into account.
Well, it's the same thing.
But won't the application be a sort of argued case with evidence and so on?
It is, but that is what is then reflected in the decision. But and I'm going to come and explain why that's legally impermissible in due course. But the important point about the CAD, and I'm going to come just to explain the difference between CADs and ordinary planning applications in a moment, is that as you'll see from this example, the CAD contains a menu of items that would be AAD. it is entirely unlike a planning application, where a planning application can only be for a specific development. You can put in multiple applications over time and you can vary them.
This is general, but within certain parameters.
This is you can have, and Quintain's got a CAD that says it can build up to nearly 100,000 square metres, and it sets out the various uses which it can have. It doesn't tell you which of those uses would necessarily be the relevant ones for valuation purposes. You can't, and one of the problems with the point about the value point that Malone Friend was making, I think was his response to something that Lord Sales raised, is that value is only determined after the CADs have been issued, because the value flows from the CADs, not vice versa. But the CADs are unlike planning applications because they contain a whole range of potential development, and Section 17 of the Act requires the decision maker not only to set out what it would do in the case of a planning application, allow, grant, refuse. It says you have to set out all development which would be appropriate alternative development. If perhaps you could turn up Section 17, pages 624, 625. At 625, subsection 5A, requires the authority to identify every description of development, whether specified in the application or not, that in the local planning authority's opinion is, for the purposes of Section 14, appropriate alternative development. So it doesn't even necessarily turn on the application. It is the authority's decision, ditto the upper tribunal on appeal, as to what should be regarded as AAD, not what is in the application necessarily. So there's a difficulty with the application point anyway. And unlike planning applications, there's no detail, and there's only a requirement, you'll see at B, to give a general indication. So what the CAD doesn't do is set out in any detail what particular development would be permitted. It sets out a whole range of developments that could be permitted, and the landowner is entitled to the benefit of whatever value compensation he, she or it can get out of it at the valuation stage. The other oddity with the Secretary of State's position, and if I try and answer some of my lady's questions about how these matters are dealt with, issues such as alternatives, cumulative impacts, all of those issues that Malone Friend identified can be raised by evidence by the Secretary of State or the acquiring authority in any event before the upper tribunal on the CAD appeal. They are not dependent upon any CAD. The CADs, as my Lord Legate pointed out, are a construct for determining compensation. The evidence is evidence which the Secretary of State can adduce in any event and does not require the CADs to adduce. It is something of an oddity, therefore, that the Secretary of State is placing so much weight on this, and I'll come back to that in due course on the unfairness issue.
Just before we leave this CAD, can you give us the bundle reference to the application for the CAD and the materials?
I'm not sure the applications are in. No, they aren't.
How extensive would an application be?
I'm sorry,
How extensive would an application be?
quite detailed. My recollection is that they are tens of pages long, if not longer.
Was the application before the Court of Appeal?
No. Nor, I think, before the Lands Chamber. The part of the problem is the issue as it's been identified by the Secretary of State has been that this is a notional planning application until Malone and Friend took the case over, and you'll see that's how Mr King put it before the Court of Appeal and the Lands Chamber. So we've been focusing on the CAD itself, but the difficulty is, as I've indicated with the applications point, even from the starting blocks, as it were, is that the CAD does not have to reflect the application. The application is the basis upon which the authority can proceed, but it can make its own mind up as to what development should be permitted, even if not in the application.
Doesn't have to reflect the planning application.
I'm sorry?
When you say the application, the planning application.
No, the CAD application.
CAD application.
Yes.
Presumably they put forward the most valuable use that they can think. I mean, they're not going to put forward warehousing and the local authority thinks a five-star hotel is...
Absolutely not. Your ladyship is absolutely right. They're going to put their best foot forward because they want to maximise their compensation claim. But equally, it's not binding on the authority, and the authority does take representations also in considerable detail from the Secretary of State, because one of the oddities about the CAD procedure compared with the planning procedure, it is as it were, a contest between two parties only, the landowner and the acquiring authority. But of course the landowner will put its best foot forward, but the authority doesn't have to accept that, and it will have the representations from the acquiring authority to consider as well before it makes its decision.
But, I mean, isn't the main point of section 17.5 A that they're not bound just to indicate that although the starting position presumably would be the application is put in, they might say, well, we accept part of it but not all of it, and therefore...
They may be persuaded by the Secretary of State
Yes.
to agree with it.
Right.
Yes. No,
but the starting position would still be the CAD application itself.
But that gives rise to two further problems. One is the application isn't evidence for anything. It is just the cases advanced by the landowner and the acquiring authority. And the only evidence as to what would be permitted in the no-scheme world or the scheme cancellation world is the CAD itself, because that's the conclusion the authority has reached, subject to appeal. And secondly, at the relevant valuation date, there were no CAD applications at all. Can I ask the court, please, to pick up the statement of facts and issues? And can I just ask the court to look briefly at Table 1, pages 5 and... I'm not sure which bundle I'm using. Apologise. I'm afraid I've been working from the key documents bundle, and the learned friends' submissions are by reference to the core bundle. Yes, it's page 205 of the core bundle. 205 and 206. If you have it in the short form key documents, it's 5 and 6. But you'll see, firstly, in each case the valuation date has been identified, and you'll see that the latest is September 2018, which is the fourth respondent. The others are earlier in 2018. If the court then looks at Table 2, you will see the dates of the CAD applications, and without exception, they all post-date the relevant valuation date. So, Quintain, 11th of February 2019, the University, 21st of December 2018, Curzon Park, 18th of April 2019, and Eastside, it made one application, 18th of February 2019, and a second on the 18th of November. But in any event, all several months after the latest relevant valuation date. So it means that at the relevant valuation date, regardless of whether the market might be aware of them after they've been made, there were no applications for the market to be aware of or for anyone to take into account at that date.
But your primary case is, it doesn't matter when they were made, does it? They said they're relevant in any event.
I made 2 points, and you'll see this is reflected in the Court of Appeal's judgment as well, my Lord, but yes. But as a matter of fact, they weren't in existence at the relevant date. And that, in one sense, is determinative of the issue, in my respectful submission, because there's nothing to have regard to.
Well, is it because the issue seems to have narrowed, rather, and on the case now put, I thought one thing that's being said, at least, possibly even the only thing, is that you could look in the CAD application and you might find there useful information about the size of the neighbouring site and its suitability for student accommodation and so forth, and that could be evidence about the facts on that site that were in existence at the relevant date and which could be relevant to your valuation exercise.
Except there were no applications at the relevant valuation date, and that is the date by which you judge.
Well, there may not be any applications, but the information that's contained in those applications could be circumstances which did exist at that date, rather like the comparable sale after the valuation date.
True, except that they are real-world events as opposed to hypothetical counterfactual events, which is what this is. But can I just say this? If that is the way the Secretary of State's case is now put, apart from the fact it's a complete change from below, it is nothing to the point, because there is nothing to prevent evidence being put in about the availability of other sites. The question my lady was asking about multiple sites, you know, you've got a vacant site next door. Is it something you take into account when deciding whether or not you permit the application site to be developed? Those are all matters that are relevant anyway.
But if you've got the whole pack of material dealing with all that stuff, why can't you have regard to that?
Well, because my primary argument is it's a scheme world construct, and it's forbidden because of Section 14.5, and I'll come to that.
Right.
But there seems to be a sort of proxy war going on here. Yeah. That's all focusing on the CADs. But what the parties are really arguing about is whether it's possible for there to be 4 different sites, each with a CAD decision,
yes,
each for an independent development, and hence the valuation of the land on the basis that has that planning permission, yes, when in the real world you would never get those 4 planning permissions. Now, it seems to all be focusing on this issue of whether does that not turn on whether you take the CAD applications or decisions into considerations. But that's what we have to decide, because that's what the issue is.
Well, my lady puts her finger on the point. The reason this point is being run is because the Secretary of State wishes the CADs to be used against each other to reduce compensation.
Yes.
And that's the purpose. That's why we're here, and didn't walk away after the Finance Chamber. That is the purpose. There is no other reason for doing this, because the real-world planning considerations, subject to the counterfactuals, whether they're alternative sites, what is likely in the no-scheme world on the assumptions, are matters of planning evidence anyway. And a Section 18 appeal before the upper tribunal is almost like a mini planning inquiry. They used, in fact, under the earlier version of Section 18, to go to the Secretary of State and be run like a planning inquiry. But you call planning evidence. I did one in front of the tribunal in September. We call planning evidence. As an architect, in some cases, you may call highways evidence to decide what, in the no-scheme world, would have been likely to have been granted permission at the relevant valuation date. None of this prevents the Secretary of State advancing arguments about alternative sites. But in each compensation case, you are looking at the individual landowner. Section 5, Rule 2, posits a sale in the open market by a willing seller. It's a hypothetical sale, of course, but it is a willing seller. It doesn't posit a willing seller on any other site. So the tribunal is required, and if your ladyship requires, I can dig out some law on that.
No, I'm not worried about that.
If you only have to assume a willing seller on this site, it then becomes a matter of judgment for the tribunal as to what would be happening with the other sites. And there was discussion about availability and suitability and the like. That's all a question to be decided on each individual CAD. As it comes forward, because the tribunal has to take a view as to what would be happening on the basis of scheme cancellation. And on the basis of scheme cancellation, no assumptions would be made as to the willingness or otherwise, or suitability or otherwise, of other land. That's not to say the Secretary of State can't produce evidence to say, well, you wouldn't have got permission for development X on this land because there was a more suitable site development down the road which would allow this to be done, or there's limited capacity and this has already been taken up by existing planning permissions elsewhere. All of those matters can be run in the in the ordinary course of a Section 18 appeal, as they were run by presenting material to the Birmingham City Council.
And just on the issue that has been set as the preliminary issue, which is page 17 of
I've got that open.
the key documents. I mean, you said that the Secretary of State wishes the CADs to be used against each other, but in fact the issue is wider than that. It poses the question to what extent in determining an application for a certificate of CAD, the decision maker may take into account the development of other land where such development is proposed as appropriate alternative development in other CAD applications made or determined. So it's looking both at the application and at the determinations.
That is true. But, as I say, I'm making submissions as to why applications are not relevant as well. And
Sorry, I wasn't seeking to foreclose you on that.
My Lord, I had exactly the same page open.
Yes, all right.
Which is why I'm saying what I'm saying about applications. My Lord,
but I mean that more sort of fundamental point that you make depends upon you being right and the Court of Appeal being right on the effect of the cancellation assumption in relation to this.
I was going to do this now, but can I in that case go to sections 14 and 17? Because this turns very much on the construction of those provisions. Section 14, page 621. Now, as my learned friend has taken the court to, there are four categories of planning assumptions under Section 14: actual permissions, hope value under 14.2b, and two forms of AAD. AAD, which is prospect on the valuation date and at a time after that date. So there are two forms of AAD. We're only dealing with the first of those. However, the taking account for the purposes of Section 5.2 is inevitably focused on the relevant valuation date, and you see that emphasised in 4b. Assumptions set out, otherwise known in the circumstances known to the market at the relevant valuation date, planning permission could at that date reasonably be expected to be granted. And that date, as you know from Tables 1 and Table 2, is some 5 years after the cancellation on the launch date. I submit my learned friend is wrong to say that this is telling you not what evidence you can take into account, but only the thing to be valued, because the application of the assumptions plus the specifying of the relevant valuation date does tell you what evidence is going to be relevant or not relevant. Because evidence that was adduced contrary to the cancellation assumption, for example, a planning permission that was granted on the back of HS2 coming forward in Birmingham, for example, and no action was taken wholly or mainly for the purposes of the scheme, because even before the launch date, or indeed the CPO date, for any major scheme, acquiring authorities will be looking to acquire land in advance of their powers being granted, and indeed that was true in this case, and indeed there are other actions being taken, for example, government policy papers being issued and the like, all of which may affect what is and is not appropriate evidence to be taken into account in assessing AAD. So, in my respectful submission, it's simply wrong from a learned friend to submit that this doesn't tell you what evidence may or may not be admissible. You assume scheme cancellation, you assume no action taken, and no prospect of statutory powers, including compulsory powers, being used for the same thing or substantially the same thing. Section 17, which is the certificates procedure itself at 624, it's it's important, in my respectful submission, just to look at the opening words, which defines the jurisdiction of the council and the tribunal to entertain, because a CAD application can only be made where an interest in land is proposed to be acquired by an authority possessing compulsory purchase powers. Either of the parties directly concerned may apply. So the right to apply is dependent upon the preceding words. And where you are applying the mandatory assumptions of section 14.5, there can be no CADs and no CAD applications considered. For this reason, the statutory powers do not get out of the starting blocks because of cancellation on the first notice of deposit of the bill. No actions can be taken into account in pursuance of the scheme, and it has to be assumed that no alternative scheme will come forward with an authority possessing compulsory purchase powers. So our submission, which is accepted by the Court of Appeal, is there cannot be an interest in land proposed to be acquired by an authority possessing compulsory purchase powers applying the first three of the assumptions in section 14.5. Combination of those three make it a clear consequence of the statutory counterfactuals that there can't be a proposal to acquire because the powers have gone and no powers can be assumed to exist to do the same
How
thing.
then can anyone make a CAD application because on the assumptions their ability to do so is not triggered?
No, my lady. The CAD application can be made. It's just what you can assume once you are asking. This is a mechanism to determine what appropriate alternative development is. I'm simply making the point that...
I know the point you're making, but how does it not also then stymie your own application?
Because you are determining, if you go back to subsection 4b of section 14, you are determining on the assumption set out in subsection 5 what would be the permission reasonably likely to have been granted. I'm addressing here whether this makes irrelevant as a matter of law other applications, because the AAD determination is on the assumption set out in 14.5, and therefore you can only have regard to the existence of other applications or certificates if they fulfil section 17.1. And on the hypothetical basis of section 14.5, A, B and C, 17.1 can't be satisfied for any other CAD, because on each CAD you have to apply the disregards in section 14.5. And therefore there cannot be, on that hypothesis, another CAD application to be taken into account. And that, and with respect, we submit that Lord Justice Lewison and the Court of Appeal were right on that point. Because as my Lord Legate said at the outset, this is a compensation mechanism. This isn't attempting to square the circle with real-world planning matters. It is a device to get at compensation, stripping out the effects of the scheme to try and get a measure of fair compensation for the landowner who's been acquired. And stripping out the effects of the scheme, we submit, on the plain words of the statute, strip out the ability in that hypothetical world of anyone else to apply for a CAD. Because in that hypothetical world, there is no scheme and no ability to apply for CADs.
I think when Mr. Corner is pressed, he falls back on the sort of bottom line of his point, which maybe is the top line too, which is that you can still look at the CAD application as one way of getting to evidence about the suitability of the site, even if it may be that you could have got that evidence somehow else as well.
Well, my Lord, my answer to that is it's precluded for the reasons I've just said. the no...
Well, why does that preclude? I can see it precludes taking account of the fact that a CAD application has been made.
And the
but why does it preclude looking at what's said in it as independent evidence of the fact stated?
Well, I'd put it this way, that it's difficult to disregard a CAD application and the contents of a certificate and yet take account of the contents of the application. It seems to be taking away with one hand and giving back again with the other. And that, I would submit with respect, is inconsistent with the statutory assumptions. If you can't make an application, there can't be an application for you to have regard to in the no-scheme world on those assumptions.
But I mean, what's in the application is different from the certificate, as you yourself have emphasised.
Yes, but there can't be an application or a certificate on my submissions.
Well, it might be helpful for us, since this seems to have become the crucial issue, to see an example after the hearing of what one of these looks like, because then we'd have a better idea of the kind of document that we're talking about.
I'm sure your lordships and my lady would be delighted to receive some more paper, but I'm sure we can give you an example or two examples.
The consequence of what you say is, you say that when the decision maker is faced with 4 CAD applications for identical let's assume this is a scenario. The decision maker is faced with 4 CAD applications for identical developments, each of which fully meet the development need. You say that the consequence of having to ignore the others is that they have to, in effect, grant assumed planning permission for 4 developments, and that compensation is then assessed for each of those, totally ignoring the others. Now,
yes.
That's what you say is the consequence of your submissions, as I understand it. But if that's not the consequence, then I need to know why.
Yes, it is.
It is, yeah.
I thought it wasn't the consequence. I thought you were accepting that there could be evidence. We'll have to be. I'd like to be clear because.
I'm sorry. What I have said is that planning evidence can be adduced on the appeal with regard not to the CADs and not to the applications. Evidence can be adduced as to the planning considerations that may bear on that particular site.
And they might show, I think you accept, don't you, that there's only a finite amount of residential accommodation. There's another site that is incredibly suitable for it, and in those circumstances we don't think there's a reasonable expectation in your notional world you would have got it.
But your lordship is assuming that in the no scheme world that those other sites would be coming forward. The only site that you have to assume a willing seller for is the subject site. That's a matter of law.
That's the additional point, isn't it? Then that the additional step that you need to take.
Yeah.
To get to the result you want, which is 4 lots of enough student accommodation.
Well, that's putting it, if I may say so, a little tendentiously, because the dates are different for each of the applications. Well, I know they're not that.
I'm still trying to get to this position, which I think my Lord Legate is also asking about. Is there anything that you accept a decision maker looking at Site 1 CAD application, let's assume, as I say, that it's for everything that is actually needed for a development policy purpose, is there anything that he is entitled to look at to say, I'm not going to give you a certificate of appropriate alternative development because there are these other sites which are just as suitable and which might be brought forward to build student accommodation?
If there is evidence adduced in the individual CAD cases as to what the position would be in the no scheme world, there are potential planning considerations for cumulative impact and the like. What one should not assume, my lady, the difficulty is in order to get to that point, you have to assume that each CAD application is like a planning permission or like a planning application, because the timing of any valuation date is entirely within the control of the acquiring authority. In the no scheme world, and this is something the Lands Chamber and the Court of Appeal mentioned, there's no guarantee that the landowners would have been looking to bring forward their land at the same time.
But isn't that something you take into account, or the decision maker takes into account when assessing what the no-scheme world, hypothetical no-scheme world would have looked like.
Yes, but it's simply...
So, I mean, and isn't that just a matter of evidence? So sometimes you may be persuaded, well, there looks like a site that might have been good here, but for various reasons, we're not persuaded in the no-scheme world it would have been brought forward. Conversely, there might be evidence that would persuade you that in the no-scheme world it would be brought forward.
And the Secretary of State can adduce evidence at the hearing before the upper tribunal. What I resist is the notion that just because it's in the CAD application or the CAD decision, that it should be taken into account and then weighed for whatever relevance it has. It is, in my submission, for the reasons advanced by the Court of Appeal, a breach of the statutory counterfactuals, because you cannot have, in the hypothetical world posited by Section 14(5), a situation where you consider other applications which simply cannot be made in the no-scheme world.
It's probably my fault, but I find that answer a little bit hard to square with what you seem to be saying immediately before that in constructing the no-scheme world and looking to what would have happened with planning permissions in that no-scheme world, evidence can be adduced about what alternative...
But not by reference to other CADs. It can be adduced in the ordinary way by calling witnesses, planning experts and the like.
Right. Well, I suppose I come back to the question I asked you before. If you've got a whole pack of materials, which is the CAD application, which is a particular landowner putting together a sort of shadow case for what planning permission could have been granted in the no-scheme world, and they put in a certain amount of evidence in support of that. They've compiled, as you accept, a mixture which will maximise the value for a scheme in that world.
Indeed.
Why can't the decision maker have regard to these materials for whatever evidential value they may or may not have in relation to the assessment of the no-scheme world?
For the reasons I've just indicated. Learned Friend submissions proceed on the basis of, well, why shouldn't you? My answer is the reason you shouldn't is because the counterfactuals require you not to. It is assuming that material is necessarily relevant. That's a matter for the Secretary of State to adduce as a matter of ordinary practice at the appeal, or to the planning authority in the first instance.
I mean, forgive me, I'm not sure that it is assuming it's necessarily relevant. The relevance or otherwise of it is going to be a matter for assessment by the decision maker. Sometimes they may look at it and say, yes, you know, this doesn't begin to show that in the hypothetical no-scheme world, another site would have come forward. It's in the inchoate bracket, not relevant.
No. True. But let me just approach it this way. The court shouldn't be led into thinking this is straightforward because you've got 4 sites adjacent to each other where vesting occurred within months of each other. This is a principle that's got to be applied across the board. There are important factors, in my respectful submission, set out in our case. The first is the date of vesting is within the statutory powers a matter for the acquiring authority. You do not even have to vest the whole of the landowner's title at the same time. And under the HS2 Act, a period of 5 years, subject to extension by the Secretary of State, which wasn't issued, you've got 5 years to vest across the whole scheme. You've got different...
Sorry, just to pick you up, why do you say that's such a significant point?
Because it leaves the matter within the control of the Secretary of State as to when your relevant valuation dates are.
Yes, but at whatever is the relevant valuation date, you're still going to have to ask the question posed by Section 14(4)(b).
Can I?
Well, just to make the point,
Yeah.
By whatever evidence is available to construct the no-scheme world.
That is true, but equally, it doesn't follow that in all cases CADs for the same area will be within the same time period. The date for the application of CADs is only constrained by subsection 2, which says you can't apply for a CAD without consent if it is applied for after the notice of reference to the tribunal for compensation to be determined has been made. So at any time up to the notice of reference, a CAD can be applied for, so it can be at any time after vesting. learned friend is wrong to say, well, you can issue a CAD at any stage after the launch date for this reason. Until vesting has taken place, you do not know what the valuation date is for Section 14 purposes. So it is simply inconceivable anybody would seek CAD when they didn't know what the relevant valuation date was, because you don't know what you're aiming at. So learned friend's wrong, in my respectful submission, to argue otherwise. Similarly, as he mentioned, there is no reason why alternative appropriate development has to be determined by the same method. A CAD is a non-mandatory means of dealing with what is appropriate alternative development, and there are three others at least. One is simply to agree the matter, so the assumptions never become known. Two is to make a notice of reference and to have the planning assumptions decided as part of the overall reference. That is not an infrequent occurrence.
Sorry, when you say notice of reference, is that to the upper tribunal?
That's the notice of reference which actually seeks the determination of the compensation. It's effectively the commencement of the compensation process.
In the upper tribunal? In
the upper tribunal,
yes. Okay.
Yes. I mean, you have to give notices of what you're claiming and that sort of thing, but then that sets the process going in the tribunal. The fourth is by what used to be called a lands tribunal contract, where the parties agree at the compulsory purchase stage to hand over the land, so there's no fight at inquiry or before select committee about whether there should be a compulsory purchase order made. And what the parties do is they agree a minimum amount of compensation, and then to arbitration in the lands tribunal, the lands chamber, if they can't agree the compensation. And that's done under Section 1.5 of the Lands Tribunal Act 1949, which now, because of the Tribunals and Inquiries Act, only refers to the Lands Tribunal Scotland, apart from Section 1.5, which says these arbitration applications can still be made to the Upper Tribunal and the Lands Tribunal of Scotland. And those arbitration proceedings, of course, as in all arbitration proceedings, are private. And so any decision by the Lands Chamber as to what AAD may be in that case wouldn't be known to the market because they would be confidential proceedings. So there isn't even a single method which allows a general approach to consistency. And it may simply be random luck as to how many CAD applications are made and how many aren't. And it's dangerous in my submission to elevate the approach that the Secretary of State wishes to take to a general principle because of those difficulties. Also matters that appear in the Court of Appeal judgment. My learned friend eschewed calling these notional planning applications, but he did actually say so at one point. I'm assuming he's not saying it's a notional planning application now, but I was going to say there is more than one difference with a normal planning process, as I'm sure your Lordship, my lady, will be familiar with. Section 17 is a self-contained procedure, compensation mechanism. There is a very limited involvement and, of course, there is no public process in the sense of a public consultation, widespread discussion with statutory consultees, highways authorities and the like. There's no environmental assessment, a whole range of things that are done at a planning stage. So it's a very basic means of getting at the matters. And most importantly, it doesn't end up in the equivalent of a planning permission. It ends up in a certificate saying this is a range of uses that would be acceptable.
And when it goes then to evaluation, which of those uses is the one that is the basis of the valuation?
Matter for the tribunal.
According to which criteria?
The tribunal will look at the CAD and reach a conclusion, presumably, as to which is the most valuable combination of uses.
So it chooses the most valuable.
Well, I can't say that, but
But it's no longer, is it, considering probability, as I understand it?
No, it's converted
so it's purely a matter of value now.
It's purely a matter of value, and I would have expected them to, urged on by the claimants, no doubt, to take the most valuable combination of those uses.
Yeah, so just to wonder about that. I mean, if you've got a CAD, or indeed a determination by the tribunal of a range of uses, any one of which would be AAD. Yeah,
or a combination of which, yes.
Yeah, how does one decide, for the purposes of valuing, because the value of the different combinations may be different, which one you go for? Isn't there some sort of assessment? Well, you tell me how it works.
This sounds like a feeble answer, my lord. It's a matter for the valuation experts to put forward the cases to which the tribunal should select as being representative of value, having regard to the factors in the statute. It's not much of an answer, but it is a valuation question. Right. So if you've got, I imagine it works on the basis that you produce what you think is the most valuable range of uses, or you put forward alternatives to the tribunal, which I've certainly seen done in the past.
Yeah, but it's a two-party process, so obviously the landowner will be
and the
saying,
inquiring
make it high.
the opposite, yes.
Yes. Secretary of State or whoever will be saying, make it low. How do you decide which to go for?
Well, the tribunal decided on the balance of the expert evidence.
Right, okay.
I mean, it is purely a valuation question for the tribunal. And you can see why the courts have deprecated too much hypothesis rather than less, on the basis the tribunal's job is already quite difficult on the basis of the Section 14 and Section 17 certificates in any event. I'm sorry there's not a clear answer to that, but it really is a question of valuation at the end of the day.
But you say it's not, at that stage, they would also be precluded from taking into account the existence of any CADs relating to neighbouring sites.
Yeah. Because, I do, my lady, because standing in the no scheme world, using that as shorthand, the willing seller whose value is being looked at would have to look at material planning considerations, relevant evidence. The fact that CADs are being made in the scheme world doesn't mean that applications would be being made in the no scheme world. So you'd have to have specific evidence as to the likelihood of other sites coming forward. Because as I've submitted, you're required to assume a willing seller for the subject land. You're not required to assume that everybody in the area is a willing seller. And that may be where this comes down to the real point, which is you can't assume that because CADs have gone in, that the other landowners would be in a position or wish to sell at that time. They're not, those landowners are not the hypothetical willing seller. They are individual landowners, and they may want to land bank. They may have other plans for the land in the no scheme world.
But I think your case is not that you can't assume that they would come forward, but that you must assume that they wouldn't.
No, my case is you cannot assume, just because CAD applications have gone in a particular form, that the landowners would have done the same in the no scheme world.
Well, I think the appellant also accepts that, so you're ad idem on that point.
Well, in which case I'm not sure why the Secretary of State is pursuing the point. Because I do not suggest for a moment that planning evidence can't be adduced on a Section 18 appeal. I simply say that you can't assume that what's in the CAD application would be what happens in the no scheme world.
But I don't think Mr. Corner was saying that.
No.
My Lord, the Secretary of State has said...
He was saying that, well, the Secretary of State may have said a number of things at different stages, but I think with respect to him, Mr. Corner was clear before us that he's saying the CAD application provides potential evidential material to which regard may be had for whatever worth it or weight it may be found to have, as potentially giving an indication of what the no scheme world would have looked like. He's not saying it must be assumed that these things that happened in the real world under the CAD would have happened in the no-scheme world.
In which case, my lord, I ask the question, given that you can adduce evidence vis-à-vis the no-scheme world as to what might have happened with other landowners, given that you could look in the no-scheme world at what else was happening, to the extent that you're dealing with a period where the HS2 is stymieing development anyway, so it's a difficult exercise for the tribunal. But you are not assuming that because they put in CADs that they're applying. I respectfully suggest that there is no purpose in my learned friend's submissions, because the CADs, on his case, if that is right, add nothing to what you can do in the no-scheme world. What I say you can't...
They might add something, I think, is what he's saying.
Well,
that's all he seems to be saying now. It's not much for him, but
well, I just, having argued this...
What he thinks he needs to say, given that the decision maker in this case seems to have thought that the consequence of accepting your submissions was that he had to ignore everything that had gone on and ignore the potential for other development in other areas equally suitable for student accommodation building, and just treat everything completely silent.
Milady, that would be a very unfair way of characterising. We were responding to submissions being made initially by the Secretary of State's then solicitors on this issue, and then to the preliminary issue being brought. And it has been argued until now that the CADs should be taken into account, and not just the applications, and that they were notional planning applications. The learned friend Mr. King's skeleton argument in the Court of Appeal in the Lands Tribunal is at the back of the core bundle. I'm not going to go through it, but that is what has been said until now. What you now have appears to be a very attenuated form of case on the part of the Secretary of State. And I simply say this. Evidentially, the Secretary of State can adduce whatever evidence is considered to be relevant in the no-scheme world, and no one suggested otherwise. What I do resist is the notion, which may or may not be, your Lordship, my lady, don't seem to think Mr. Corner is submitting this, but you can't take into account that because there were CADs, there were necessarily planning applications, because of CADs are just forced on the landowners through the choice of the Secretary of State to vest. Equally, I would submit you can't take account of the content of the applications because they are scheme world constructs as much as the CADs themselves. The applications are only a consequence of the scheme. And so if you accept that the CADs are not legally admissible, then the same must be true of the applications, because they are all constructs of the scheme. They only arise because the launch proceeded and the powers were granted and vested.
Why should the application, in principle, be incapable of giving you possible relevant evidence germane to the construction of the no-scheme world? I mean, the fact that an application has been made does tell you something about the world, and there may be all sorts of arguments about to what extent it can be translated across to the no-scheme world.
My Lord, all it tells you about the world is that someone's had their property compulsorily acquired, and to take my lady's observation, it may be from a company that's going insolvent, but it wants to maintain the value of its compensation.
Right, but it goes a little bit beyond that, because the company has had its property compulsorily acquired, and this CAD application is how it thinks it best maximises the return from that land.
Across a road.
Admittedly, in the compensation world, not
yes.
The real planning world, and it's something different from the no-scheme world.
Yes.
But it does, one might think, tell you something about how the landowner thinks that their package could be put together to maximise the value from its property.
But landowners on others, I take just one of my clients. Landowners on other sites are putting forward hypothetical cases, which are scheme constructs, scheme world constructs. When we present our case on the merits to the upper tribunal, there will be evidence as to what is relevant in the no-scheme world. we say that requires evidence which is particular to that. We do not assume willing sellers on other sites. We make no assumptions about what other landowners might be doing, because you cannot assume that other CAD applications would be made, let alone determined. So, given it's the Secretary of State, in any event, the Secretary of State can adduce the evidence, but without the trappings of a CAD to give it some sort of added weight or added advantage. And it's simply nothing to the point to say, well, we can take account maybe of the evidence in the application when the application falls to be disregarded.
Yes.
I mean, there's no detriment to the Secretary of State other than the fact, the only detriment that can arise for the Secretary of State is that if the Secretary of State can have taken into account applications, then it allows the Secretary of State to say, well, you shouldn't have compensation having regard to these other sites. That's an exercise that should be determined in the no-scheme world for each site. As the Tribunal and the Court of Appeal said, there are consequences. You can't just assume it's unfair compensation or not part of the principle of equivalence, because you may have 4 sites which generate similar development. The fact is it's a balance struck by Parliament, and Parliament has taken into account, in my respectful submission, the fact that the parties have had their ability to control their own land and to control the pace of development as they see fit taken entirely out of their hands. So it's a quid pro quo. The other difficulty is it becomes a first-past-the-post exercise. And you'll see this reflected in the Court of Appeal when Lord Justice Lewison dealt with what Mr. King was submitting as to how you would actually square fairness between the different parties, all of whom have got different valuation dates, all of whom have got different CAD application dates. Is it the first in time? Is it the first to get to the tribunal, or the first to get the CAD? Takes all the benefit, and everyone else is only left holding what's left.
Well, the answer that's put forward, as I understand it, is that nobody has preference, but the evidence at any time, the time any one application is being considered, is whatever the evidence is at that time.
But that's a first-past-the-post argument, and that seems to...
Forgive me, I don't think it is a first-past-the-post argument. You will look at the evidence on the first application for a CAD, and it may be that that evidence shows that in the no-scheme world there would have been 3 other potential sites, and then one does whatever exercise is necessary to take account for the fact that there are multiple schemes capable of meeting one, let's say, point of required demand.
But what I resist is the idea that you automatically assume that there would be 3 other schemes.
No, I agree. Well, I don't think Mr. Corner is saying...
I think he's given up on that point.
Well, if you
assume that.
You may be leaving him with the emperor's new clothes if you go down that route. As I say, it's not the position that was adopted earlier, and I'm sorry if I'm fighting against it. A case that is not being run against me any longer.
I think it's a consequence of his position, or he'll correct this in reply if it's not, that you could have 4 applications which all get allocated a reasonable expectation of being awarded the residential accommodation.
Yes.
Because that evidence may not show that anybody was, as it were, going to apply in the real world for it.
Yes. Well, can I just, on this question about inequality and the statutory and the question of fairness, I just draw the, I don't need to take you to it, paragraph 62 to 65 in the Land Chambers determination, which is pages 363 to 364, which makes the points at slightly greater length that I've just been making about fairness, and also in the Court of Appeal, trying to get the right page references for the court. Yes, Lord Justice Lewison, paragraphs 58 to 63, pages 339 to 340 in the core bundle. I just asked the court to look at those. The problem is if it is simply a level playing field for each application, not making any assumptions about any of the others, I'm not entirely sure what the purpose of the preliminary issue was, because as it was originally formulated, it was to deal with the fact that each was relevant to each other, and therefore it would have a reducing effect, particularly after the first application was decided. So we're faced with a slightly different...
Well, I think that point plainly has not been abandoned insofar as one's looking at the valuation exercise in the upper tribunal, not least because, as I understand it, there are 4 contiguous areas of land already cleared for development, ripe for development, which one would
as a
expect.
result of the scheme.
Right, okay. I
mean, to give you one example, Quinte, one of my clients, had permission for hotel and mixed use. It half built the scheme. The hotel was built, but it had to abandon going any further forward because of the notice of the HS2 scheme.
Right. Forgive me. The only point I was seeking to make was that I didn't think Mr. Corner has abandoned the possibility of arguing at the valuation stage that there were potential alternative sites for these forms of development.
My Lord, as I keep saying, as difficult as it may be for him to do that, given what the authorities say, he's entitled to do that. What I'm just trying to shut out is the fact he's entitled to do that by reference to the CAD applications.
All right. Just to take up what Lord Leggett put to you, that you could have 4 possible sites, but in relation to which, on the evidence in the no-scheme world, none of them would have come forward. And I think it must be right that in that situation, each of the owners of the 4 sites would get, if you like, full compensation or compensation on the basis of that. Sorry, just to complete the point, because I just wanted to make sure that this was on the table. Not least because I think Mr. Corner accepted that part of the assumptions that one makes for the valuation exercise do not include the owner of the particular land to be valued proving that they themselves would have made an application for planning permission. That's not part of what they have to show.
Slight difficulty. As I said earlier on, the valuation issues come after the CAD, so it's a bit difficult to foresee that. All I can say at that point is the landowner seeking compensation in any specific case is on the basis of the hypothetical willing seller in Rule 2. There's no other hypothetical seller involved on any other site. So the hypothetical sale can't be on the basis of the landowner's own particular preferences. But
no, I was talking about the application for planning permission that
others might make.
Well, no. I mean, Section 14.4 this arose very much out of questions my lady was asking Mr. Corner. It does not require that when one's constructing the no-scheme world, that one asks the question, well, would the owner of the particular property...
Would the applicant have applied? He might have not wanted to do anything with his land.
It's irrelevant because you're assuming a willing seller.
Yes.
Section 5, this is all an exercise that goes back to Rule 2, and Rule 2 requires you to assume a willing seller.
The willing seller is the willing seller and willing buyer. That's the compensation. You're not talking about the willing seller here. You're talking about a willing developer.
Yes.
You don't have to assume. I ask the question, is the reasonable expectation in 4.4b, is that you have to show that you would reasonably be expected to have put in an application for planning permission for whatever, or do you assume that you have put in the application for planning permission and then what would you reasonably be expected to be granted? And I think Mr. Corner said it was the second of those. That
I agree with that you don't have to make any assumptions about whether any planning application has been made. You simply ask the question, what assumptions do you make as to what would have been granted planning permission on that date?
If it had been applied for, assuming it...
Well, you've got to assume it would have been applied for.
Yes, in the sense, it's slightly the opposite of what you said. You said you don't make any assumptions. You do make the assumption that a planning application was made.
Well, you can't do.
You don't have to prove that.
Exercise otherwise.
So you're trying to find out what was the value of the land in planning development terms. Whether the person would actually have wanted to realise that value is neither here nor there.
Yes, because the developer's had his land taken and is simply trying to maximise his compensation. Yes. So yeah, I agree with Mr. Corner that you don't have to look to see whether there was an actual planning application or assume an application had been made. It's simply the fact that you have to determine whether there are reasonable prospects, etc., at the relevant valuation date. But you're not thereby engaged in an exercise saying, well, what would you do with other sites, except by the application, Lord Hope in Fletcher Estates of applying ordinary planning principles, except insofar as precluded by statute. And I've said it more times now than I ought to have done, and apologies for saying it again, but for the reasons I've given, we say that you are precluded from considering the applications and the CADs, and that the Court of Appeal was right, particularly on the case then run by the Secretary of State, where alternatives and the like were only given as examples, not as the front runner. But that then just brings you back to the no-scheme world and the matters before the tribunal, and it will hear evidence and decide whether there were other sites that would have been runners that were likely to have come forward. Because as my lady pointed out, just because a site may be may be suitable, doesn't mean that the landowners in the no-scheme world would have made it available. If absent CPO powers, if landowners don't wish to develop, they don't wish to develop.
But this procedure that Mr. Corner mentioned, this what was it called, where you can, the local planning authority can make its own inquiries of other neighbouring owners of land that looks as if it's suitable. Are you likely in the foreseeable future to be making a planning application? You recognise that as something that sometimes happens in ordinary planning terms?
Not quite. If a local authority thinks that there is an issue because there's a particular impact, perhaps a landscape impact or something of that description, which warrants it, they usually ask the applicant to review suitable alternative sites and to review whether or not there's evidence of availability. It's done all the time in the context of retail planning when you're looking at what's called the sequential test, and you have to decide whether there are sites other than town centre sites that are suitable, available and viable. Just because they're suitable and viable doesn't mean they're necessarily available. And indeed, I've got a case on precisely that point in Northern Ireland next week, where there's an issue about whether someone wanted to put a new bus scheme through the middle of the site, and therefore it wasn't available. So there may be a whole reason, a series of reasons why it may not be available. Lord, can I just check whether there's anything else I'm...
We seem to have come down to an issue between whether the CAD applications are inadmissible or whether they're admissible but unlikely to contain any evidence of any relevance.
Lord, that's how it appears to have shaped up. And your Lordship have and my Lady has my submissions on the issue of relevance and the counterfactuals. Can I just deal with the issue of consistency, which I think came up briefly? My learned friend referred to something I'd said in the Lands Chamber at paragraph 52. That was given the way the arguments panned out in the Lands Chamber. We did not run the same argument in the Court of Appeal and indeed put in a respondent's notice. The point about consistency, in my respectful submission, is really a matter of administrative law consistency in decision making rather than detailed consistency comparing evidence with evidence. And the typical point would be, is the decision maker interpreting the same policy consistently? So in my submission, it goes really not much further than a fundamental basic level of legal consistency in the sense of consistent interpretation of policy. It doesn't require a line-by-line comparison with evidence.
Yes.
And
Just on that, just to explore how that would potentially work, and presumably if you had a series of CAD applications to the local planning authority, they would be bound by the usual public law requirement of consistency in interpretation of policy, let's say. So that each CAD would reflect, that they issued would have to reflect that. But then we've been shown that under Section 17, the upper tribunal is not bound by what they've decided. They start again. So presumably, the upper tribunal wouldn't be bound by any consistency arising from what the local planning authorities decided, but would have to operate its own powers consistently.
Well,
is that how it works, is basically the
indeed,
question.
the Court of Appeal no doubt would have something to say if, in dealing with two CADs on adjacent sites, the Lands Chamber applied a different interpretation of policy to each. But yes, it is a simple fairness principle, but once you're on appeal in the Lands Chamber, then the Lands Chamber is there at first instance. Just for completeness on that point, Section 17 does make it clear that a CAD means a CAD as varied. Subsection 18 on page 625. So if the Lands Chamber, excuse me, varies or replaces the certificate as it may do, then the CAD is that CAD and not the initially issued one. It's the other half of the power in the tribunal to confirm, vary or cancel it and issue a new one. The tribunal has to issue a CAD in any event, because even if it concludes that there's no AAD, it's got to certify no AAD, because that's equally binding in the compensation determination. If you look at subsection 7, it can issue what's called a negative certificate, i.e. no AAD, so the developer gets only existing use value. I'm reminded, just to make the point, that it doesn't... the fact that the CAD process is a very constrained process means that it shouldn't be assumed that the existence of CADs in other cases are known to the market. We simply have a series of events here which have brought them together for a preliminary issue. And as I've already submitted, they all post-date the relevant valuation dates, and the market would be far less likely to be aware of CAD applications than planning applications, because there's no publicity, and they are restricted to a dispute between the acquiring authority and the landowner.
But there's nothing confidential about them.
There's nothing confidential about them, and there's nothing confidential about the decision itself. But you'd have to positively show, in my respectful submission, that they were known to the market, and couldn't simply assume, as you would with a planning permission, that they would be known, because they're required, planning permissions are required to go on a public register.
I'm not sure that I'm following that submission. I thought that the CADs and the applications were being relied upon for the purposes of section 14.4b, which is, well, I suppose it's looking at the circumstances known to the market at the relevant date. But it's really looking at whether planning permission could reasonably have been expected to be granted on the relevant date for that particular site.
Yes.
And I mean, it will often be known that there are other potential competing sites, and I think even you actually accept that notionally that could happen.
It might be.
Yeah.
I mean, certainly in this case, the same agents are acting on a number of the applications, so difficult not to. But it doesn't follow that if you're looking at this as a matter of principle, that determinations of AAD will be known generally to the market, because A, as I've already submitted, we're dealing with different periods, and CAD applications may come in at different times and not as close together as these. And secondly, there are other means for determining AAD other than CADs, and they may not be publicly known.
Just on the consistency point, presumably once a CAD is issued, that is then a public document.
It is, but
does it go on a register?
I don't think it goes on the public register, no. It's not like a planning permission. Because it's a compensation determination.
No, I follow that. It just gives some doubt as to how the consistency argument then works if the next person coming along possibly doesn't even know that the first CAD has been...
It may be very difficult to run.
All right, but I suppose the local planning authority would, in those circumstances, in the spirit of full and frank disclosure, have to say...
It might.
Yes, all right. Okay,
and if your lordship thinks about where the principle arises in North Wiltshire, that's in the context of different planning appeal decisions, which of course are eminently public documents.
Yeah, thank you.
Yeah, and as I've said, timing is, not only do you have different modes of determination, but you have the fact, as a matter of principle, they can take place at different times. The CADs all came in relatively quickly here. You have a limitation period of 6 years to claim compensation, so even for vesting dates which are close together, you may not have CADs or indeed applications for compensation for a significant period of time. And it's just my need to emphasise that the process for taking account, for making and of taking account of alternative development is one which is partly dictated by the Secretary of State's timetable, but also partly dictated by very wide entitlements to bring proceedings over a protracted period of time. And therefore, the notion of there being general principles about cross-relevance of applications in my submission is a very difficult one. And it's best resolved in my submission by having regard to the statutory assumptions as I've already submitted.
Any questions at this stage? No. Thank you very much.
Thank you.
Would you like
No.
Thank you. Can I have my submissions?
Matters have rather accelerated. They slowed down initially. We've made up a good deal of ground.
I've had a word with Mr. Glover, and what we thought, subject of course to how things go, because we may be quicker, but what we thought was that we would divide the time up between now and 11 o'clock. I think it was 11:30, which is when we're both supposed to have finished. If that's acceptable to the court.
Yes, if you'd be kind enough to indicate to us what you're each going to cover, if you're insofar as you're adjusting your respective written submissions.
Absolutely. So I've got three...
Are you saying that you're going to use some of the time that wasn't taken by...
Basically, that's it, yes.
So you're seeking to enlarge your time estimate,
if we need it, but we are moving quicker than we had thought, and therefore there might be some matters that...
Let's see how we go.
Yeah, exactly. So there were three topics that I want to address, and I'm going to address them in this order. Reality versus assumption, the principle of equivalence, and the need for certainty. And I rise to my feet, having heard the argument, mindful of what Lord Justice Mummery said at the end of his judgment in the Harbinger Capital case, where he said, "The simple truth is there are limits to the process of rationalising interpretation, and you find that you've reached, as I have, the point of seeming to say the same thing over and over again in different words."
Well, we'd certainly discourage you from doing that.
I will try and avoid that, but I can't make any guarantees. So let me say something about reality and assumption, and I use that really as the context heading for dealing with this question about what is really the role or the relevance of the CAAD applications and certificates as compared to the evidence that might be in them, or what they are claimed to be evidence of. Certainly my understanding of the Secretary of State's case, and it's reflected in the framing of the preliminary issues, is that it was the grants of certificates themselves and the applications themselves, which are said to be relevant in some way, as opposed to any information they may contain. And we see from the way the Secretary of State puts their case at the beginning and in the end, and it's the references that the court was taken to at the end of Mullen and Friends submissions, that the point seems to be that the applications and the certificates are evidence of things, that are...
Or may or may not be. May
yes.
not contain relevant evidence.
Yes, may or may not be. And it's important the may or may not be, because it raises the question, as the court has asked of Mr. Corner, how does the decision maker know if they are or aren't? And in my submission, the only way of knowing if they are or aren't is to actually compare what one might hypothetically infer from the fact of an application being made or a certificate being granted with the actual real facts. And if the real facts coincide with the inference that might already have been drawn, then hypothetically the certificate application or the grant might be, but it doesn't add anything. It doesn't add anything. In other words, it's always the real facts which are relevant. It's always the real facts and the evidence which is what is determinative. And I want to take the court to a passage in the Harbinger case in Lord Justice Mummery's judgment. It's at paragraph 122, and it's found at page 860 of the bundle, and it sets out quite nicely what the interplay is between the principle of reality and assumption. And although this is a case concerned with valuing shares, the court was here interpreting a statutory provision which required it to make an assumption. Can I ask the court to read paragraph 122? And the point perhaps to focus on as a lens through which to see the Secretary of State's submissions is the sentence, if you're not required by statute to depart from reality, you must stick with reality. Now, we all accept as respondents that there may be evidence that's relevant about what's happening on other sites that can be material considerations in the assessment of a certificate application. But unless there's a statutory provision that allows an assumption to be made about that, that question must be addressed by looking at actual evidence. And so, in my submission, it's not open to the Secretary of State to say that a certificate application or a grant of a certificate of itself can in any circumstances be used as evidence to prove the real world situation of what the position would have been had the scheme been cancelled. Why?
Already to say what the position would be had the scheme been cancelled. We're looking at not a real world position, we're looking at a hypothetical one.
It's a hypothetical, but the question still arises, is it a hypothetical that's permissible to be proven by way of an assumption? Let's assume that if a certificate was applied for, this tells us something, or is it something that's to be addressed by actual evidence from witnesses that says this is what would have happened in the scheme cancellation world? And every time the Secretary of State claims that the fact of an application or the fact of a grant of a certificate can be used as evidence, without more, that's making an assumption. It's making an assumption that the mere fact of the application being made or the mere fact of the certificate being granted can tell us something about what would have actually happened. And of course, Mr. Corner has to say, well, may. It may be, it may not be. But as soon as one says may, one is driven to accept that the decision maker would have to look at the real facts, the actual facts of what witnesses or documents are saying about what would have happened. Well, once
so
that...
You say there would be nothing inconsistent with each of these site owners putting in their own CAAD application for this development and then giving evidence at the hearings of each of the others to say they, on those circumstances, would have put in a planning application for that development.
There's a question about whether that evidence is relevant and permissible, but in principle, if it's relevant and permissible, then evidence can be brought to bear on that.
I thought you were accepting it is relevant and permissible.
Well, there's a question. There's a question about the extent to which, in the scheme-cancelled world, it's permissible for the decision maker to reconstruct events. In other words, to ask the question, what would have happened and when had the scheme been cancelled? Would my clients have come forward at some time before the valuation date and applied for such and such a permission or not? Would they have...
Well, that just highlights that what you're talking about is not reality. It's a counterfactual world.
It is.
And the point really is, isn't it, that each person applying for a certificate is making the application on a different counterfactual assumption because it's particular to them. And therefore, the fact that somebody else is making an application tells you nothing about, you can't draw an inference from that about what the answer is on your application.
Well, I agree.
Because they're different counterfactual questions.
I agree.
So one is not, doesn't tell you the answer to the other.
It doesn't. It doesn't. And the only way one can gauge relevancy is by looking at the underlying facts, which are amenable to proof with evidence. That's the reason I point to the Harbinger case, because it's about, do we prove things by reference to evidence, or do we assume things by reference to an assumption? And there isn't logically any probative value in the fact of a certificate application or the fact of a grant of a certificate. It's not logically probative of what would have happened or when it would have happened in the scheme-cancelled world, for all the reasons that have been given.
I'm just going back to your answer to my lady's question. I just wanted to make sure that I understood it, because earlier on you said that all the respondents accept that there may be other sites which would be relevant to the CAAD exercise. And I think my lady was putting to you essentially, well, if you had evidence in the form of witness statements about other sites from the other owners, you accept, don't you, that would be relevant potentially to the CAAD exercise. And I was expecting you to say yes, but you seem to cavil at that.
I said yes if that's a legally permissible exercise. In other words, to reconstruct what the world would have been had the scheme been cancelled.
That's what I understood you to be accepting in your earlier answer when you said that.
No, so there are two ways. So let me explain my position and what I understand the position of the Secretary of State to be. My position is that the decision maker on a CAD application looks at the circumstances as they in fact are at the valuation date, subject to the cancellation assumption. So in this case, at the valuation date, there are 4 cleared sites. And because there are those sites, and because there is planning policy that tells the decision maker what sites may be suitable for what, the decision maker can say, I'm aware at the valuation date that there are other sites nearby that would be suitable for this use. That's all looking at the circumstances as they in fact are at the valuation date. It's not creating any additional circumstances or looking at other evidence. There's a larger inquiry, which I don't agree is legally relevant, which is to ask, had the scheme been, assuming the scheme was cancelled, what would the parties have done in between the scheme cancellation date and the valuation date in relation to their land? I don't accept that that is a relevant inquiry on a certificate application.
Between the launch date and the
Between the launch date and the valuation date. So the answer to my lady was intended to say, if that was a relevant inquiry, it's an inquiry that's amenable to proof by evidence. But I don't accept that it is a relevant inquiry.
But on your first point, where you say that it would be relevant to take account of the fact that there are 4 cleared sites which could be suitable, of course, suitability is not the only criterion in relation to whether alternative sites are available. You also need availability, a willingness to come forward. And that's what I understood my lady's question to be directed to, that do you accept that, in principle, the managing director of the owner of one of the other sites could give evidence in your client's CAAD application and say, well, I've got to say, in the counterfactual world, my company would have brought forward an application for planning permission.
Yes. It may be that the way the cases end up being argued in the tribunal, that issue is engaged, in which case we would adduce evidence on it. But my starting point is, as a matter of law, it is not relevant for my client's CAD application to adduce evidence from my client to show that, as at the
No, not from your client, from someone else.
No.
But, well, then I don't understand why you accept that it's relevant to your client's application that there is suitable land, because suitable land is, in a sense, neither here nor there. You need suitable and available land.
Because what's relevant is what's known at the valuation date in the market. That's what Section 14 says. And the planning decision maker can see that from the known facts. The planning decision maker can see that at the valuation date, on the known facts, there were 4 cleared sites, and the planning decision maker can look at the student housing policy and the location of the sites and can say, looking at these sites, in principle, they seem to be suitable for student accommodation. What the planning decision maker can't do is, as it were, pick up the phone or ask for evidence about what would you, the owners of the other sites, have done had the scheme been cancelled years back, in the meantime, in relation to those sites.
Well, there are always questions about that sort of evidence in any context, as how far it's relevant for somebody, or admissible for somebody to express an opinion about what they would have done in a situation which didn't arise. Do they have some special hotline, as it were, to what they would have done that others don't? It depends on how close, probably, the situation is to the real situation. If it's too far away, then that evidence is pretty much no better than anybody else's opinion about it.
The reason being, and I think it's an expression used by my own friend Mr. Glover, is the factual bedrock of the CAAD decision is the circumstances known to the market at the valuation date, not the circumstances that would have been known to the market had the scheme been cancelled and people done other things in the light of that, but the circumstances actually known to the market at the valuation date. And that's why I say, to that limited extent, that the planning decision maker can look at the fact that these sites were there, that they were cleared sites, that they, in planning terms, looked like they were suitable, but can't make their own inquiries into what would any particular landowner have done.
But they may be able to draw an inference just from the facts that you've said, and the fact that landowners usually like to make as much money out of their development potential land as they can.
But how? Because as it was put to me a little while ago, we're talking about a hypothetical. The hypothetical cannot be a fact known to the market at the valuation date.
But would it be legitimate for the decision maker to say, right, looking at the matter at the valuation date, there were these 4 sites, each was equally suitable. I have no idea whether the other 3 owners would have come forward to make a planning application, but I think they probably would. And so I'm only going to grant a CAAD for a quarter of the student accommodation, not for the whole amount, because I would want to keep something back for for these other sites.
Yes. So if the basis on which that judgment was being made was facts known to the market at the valuation date, then, subject to that being a lawful application of the authorities that you were taken to by Mr. Corner, then yes. Yes. Because that's applying normal planning judgment to circumstances known to the market at the valuation date on a particular CAAD application. Entirely.
So is this right, that the market generally knows that landowners, developers are trying to make as much money as they can out of their development, and you've got these 4 sites potentially available, that one could infer from that, I'm not saying you should do, but one could infer from that there would be alternative sites brought forward potentially to meet the same demand?
If there are facts known to the market...
Well, they are. That's what I'm putting to you.
Well, that's a supposition. With respect, when my Lord says, well, it can be supposed that landowners are generally trying to make the best value of their land and so on, it would need specific evidence to see what the facts known to the market were. It couldn't be inferred that a particular landowner was, at the valuation date, minded to make an application for a specific form of development. That's a question of evidence. That's not a question of inference, and it's certainly not a question of assumption.
Right, thank you.
But it does seem, from what I've heard, that in the ordinary planning world, there would be something that the decision maker could do about that they could make inquiries or ask the applicant to make inquiries as to whether those sites were likely to be brought forward, but you seem to be ruling out that possibility in this exercise.
Well, it would be relatively rare for a planning decision maker to demand an alternative site assessment, because the alternative site assessment would need to have a policy basis. In other words, there'd need to be a reason why alternatives were relevant. And so, for example, if one is promoting an out-of-town retail proposal, it's relevant to look and see if there are what are called sequentially preferable sites, better located sites. And therefore, it's normal in those circumstances to submit a site assessment. If the development's in the green belt, so where there's conspicuous harm, it's normal to look at alternative sites. But if it's a urban site that has policy support for a particular form of development, it's not normal for an applicant to have to discount other sites, because the starting point is that their site is suitable for the development and they're applying for it now, and all things being equal, they ought to get permission.
But then normally, if they got permission, that the existence of that planning permission would then affect the ability of anybody else to get planning permission to do the same thing.
It would, and 2 things about that. Firstly is, although my learned friend's written submissions are ambiguous on this point, he did say towards the end of his submissions that he accepted that a CAAD should not be treated as using up capacity in the way that a planning application would. That's the first thing. The second thing is, it's very important that the court takes cognizance of the fact that planning is not the only respect in which a landowner's value may have been impacted by a scheme. In other words, the CAAD regime provides a landowner with the ability to claim value based upon a planning permission which it did not in fact have, right, at the valuation date. So it can make up for the fact that the scheme may have prevented the landowner from applying for planning permission. But there are lots of other things that may have happened that the landowner may have been prevented from doing. The landowner may have been prevented from getting a planning permission earlier than the valuation date. But that's not a compensatable matter. The landowner may have been prevented from getting planning permission and developing his land so that at the valuation date it was actually a fully let commercial development. Now, my clients can't claim compensation on that hypothetical basis. Had hypothetically, one of the landowners done that, it may be that the Secretary of State's compensation burden would have been far higher, because they would have been acquiring not a cleared site, but a fully developed site that was let and so on. So it would be wrong for this court to look at the particular feature of this case, where there may be 4 certificates, all of which take up the full capacity, and say that somehow that is indicative of a level of value that could not have been secured in the real world. Because in the real world, there may have been all sorts of other valuable matters that the landowners could have done with their land, which they have been deprived of. They could have sold it and invested it for greater gain, but they couldn't because of the shadow of the scheme. So it's the Section 14 mechanism is a way of redressing some of the impacts of the scheme, but it's not a way of redressing all of them. The reason I started with that is because in my submission, it's not open to the Secretary of State to use the certificate application or the grant of a certificate as a proxy for evidence of what might have happened in the scheme council world. If that question is relevant, then it's a matter to be proven by evidence of actual facts. Can I say something about the application and the information in the application point? In my submission, whether information can be looked at by a body determining a certificate application has absolutely nothing to do with whether or not it's contained within a certificate application. It depends upon the intrinsic quality of that information. It's either relevant information or it's not relevant information. The Secretary of State's point, as I understand it, is a slightly different one. It's that or at least it was, it's that the application, the certificate application itself is relevant. And in my submission, the fact of a certificate application is not relevant. In other words, if my client's certificate application were to come second and there was an earlier one that contained information, of course, the decision maker on my client's certificate application could look at the information. But it couldn't attach any weight or significance to the fact that that information happened to be in a file that said CAAD application. That would be unlawful. The fact of the CAAD application is of no relevance or significance whatsoever. Either the information is intrinsically relevant to the statutory questions or it's not, and that doesn't change.
Part of the context in which the material within it may or may not be relevant. It doesn't of itself make it relevant.
No.
But may it not form part of the context within which one assesses the relevance of the information within it?
No, in my submission, whether the information is badged CAAD application or is just found loose in a pile does not change the relevance or significance or the legality of taking that information into account. It can't. There's another feature that I want to draw attention to, and it's this. Section 14 is about planning assumptions, but it's directed towards valuation. So the start of Section 14, Section 14.1 starts by saying this section is about assessing the value of land in accordance with Rule 2 and Section 5 for the purpose of assessing compensation. So that's where everything is directed. Now, under Section 14, as my learned friend Mr. Elvin said, there are 4 kinds of planning matter that can be taken into account. There are real planning permissions that are in force at the valuation date. That's Section 14.2a. And these can be on the relevant land or they can be on other land. In other words, if we're looking at my client's case, they can be on my client's land or they can be on other land. Doesn't matter where they are. They're planning permissions in force, they're relevant. That's 14.2.8. 14.2b, also relevant, is the prospect of planning permissions, applying the cancellation assumption. And again, that prospect is relevant whether it's on the relevant land, my client's land, or whether it's on other land. None of this has anything to do with the Secretary of State's case, because these are prospect or real planning permissions. There's then appropriate alternative development. Now, appropriate alternative development is defined in section 14.4.2 in terms that mean it's got to be on the relevant land alone or on the relevant land together with other land. In other words, on my client's certificate application, the only relevant appropriate alternative development is what might be done on my land or what might be done on my land together with other land. What is done on a separate piece of land belonging to the other respondents is not appropriate alternative development.
Right, sorry, why couldn't that be other land together with other land?
Because it needs to be on the relevant land, i.e. my land, together with. So
that's my question.
It would be a red line, yes. So if we chose to put forward a global red line around all of our sites, and my client applied for a certificate, that would be the relevant land together with other land.
Yeah, right.
But absent that, there is no species of appropriate alternative development that's entirely on other land. That's not something recognised under the Act. And to go back to my lady's question, there was a question put to Mr. Corner about what would happen at the valuation stage where one party has a certificate, their land's being valued, and other land has a certificate. That is not relevant to the valuation exercise because Section 14 tells us what the planning position is that can be taken into account. Real planning permissions, wherever they are, prospects of planning permissions, wherever they are, but assumed planning permissions only on the relevant land being valued or the relevant land along with other land, but not entirely on third-party land. So that
right. So you would envisage that when this got to valuation, if all four of you had your CAADs for your student accommodation or whatever, then if the Secretary of State tried to argue at that stage, well, when you're looking at the value of that land with that assumed planning permission, you have to ignore the fact that neighbouring land has got assumed planning permission of exactly the same thing.
Yes.
Yeah.
Yes. And the very clear inference to be drawn from that is that Parliament has decided that a particular landowner's land is not to be diminished in value because of an assumed planning permission on another piece of land. I mean, the statute could have been drafted differently so that assumed planning permission on other land was relevant to the valuation of the relevant land, but it's not. And the effect of my learned friend's case, as I understood it to be, or promoted at least, is by the back door to diminish the value of the relevant land by incorporating into the planning assessment a matter which Section 14 does not allow to be incorporated into the valuation assessment. And in my submission, that inconsistency does tend to indicate that my learned friend's position is not compatible with the statutory regime, quite apart from all the reasons that have been given.
When you're, a separate question, just looking again at the CAAD, the 366, just a factual question. This envisages all sorts of costs being incurred as part of the development.
Yes.
Cycle storage, new public routes, back boxes, air quality assessment. Now, presumably they don't actually carry out all those things, no. But in the valuation of the compensation, are those saved costs that would have been incurred if this had been a real planning permission Are they taken into account
Yes.
in any way?
Yes, so these are these are costs which the valuers will take into account as the costs of delivering the scheme, and therefore that will impact the market value. There's an additional point, and I'm aware of the time, so I'll make this point quickly, and then I'll be done for today. Not only is AAD on other land not recognised, so that's the Secretary of State's point about one should be able to take into account a certificate on other land, but there's only one sort of assumed planning application that's recognised under Section 14, and it's an assumed planning permit application for AAD on the relevant land or relevant land together with other land. And we see that in Section 14.4. So Section 14.4 A says on the relevant land alone or that land together with other land. And then 14.4 B, which talks about it being granted at a later date, but then says planning permission for the development could at that date reasonably have been expected to be granted on an application decided. In other words, the only assumed application that Section 14 expressly recognises is an application for AAD as defined. And an application for AAD as defined must be on the relevant land or the relevant land together with other land.
Thank you very much. That's it's now 4 o'clock. Is there any are there any final words you'd like to say to finish that point off, or are we?
My lords, no. I'll talk with Mr. Glover this evening, and we'll.
Certainly, for my part at this stage, I don't think you should take it as a licence from this court that you have until 11:30, because you've already now had a good deal of time.
Yes.
And this court has allocated the time between the parties on the basis that you would have the time which you have estimated, and the hearing has been fixed on that basis. So you should not assume that you're going to be able to fill all the time between 10:30 and 11:30 tomorrow morning.
If I could take 5 minutes more in the morning, would that be acceptable?
Yeah. Thank you very much.